Before we begin, we have some housekeeping notes. To start, all attendees have been muted to limit background noise as much as possible. This briefing is being recorded and we've enabled closed captioning. We will have ASL interpreters on for the duration of the briefing. Our ASL interpreters today are first Holly Newstead and second Diane Saunders. If there are technical difficulties on closed captioning or if the ASL interpreters at any point go off camera, please alert us. Following the event, we will send a recording of the video and audio of the briefing, as well as a transcript to those who have RSVP'd. That video, audio, and transcript are available for you to clip and use in coverage at the outlets you represent. There are additional ways after this event we can make the briefing more accessible to you, your audiences, your coworkers, anyone else. Please let us know. There will be opportunities at the end of the briefing to have your questions answered. To ask a question at any point during today's briefing, please click the Q&A box at the bottom of the screen. This will open a window where you can type your questions. Be sure to include your name and news outlet or affiliation. We may modify or combine questions to cover as many as we can during the Q&A portion. If your question's not answered, please email our SPLC press office or the emails of our panelists that will be displayed at the end of the briefing. For SPLC, that email is press@splcenter.org. Also, please monitor the general chat where we will be placing links to resources mentioned on today's call and other helpful information. We don't anticipate any other technical difficulties during today's briefing, but if there are any challenges, our speakers may temporarily go off camera to try to keep the audio uninterrupted. This press call will focus on the anniversary of the Americans with Disabilities Act and ongoing efforts to defend and secure disability rights. For other specific inquiries on SPLC's work or the work of our partners at this briefing, you can contact that email address, press@splcenter.org. Now it's my pleasure to introduce Interim Strategic Litigation Director and Deputy Legal Director for the SPLC and SPLC Action Fund, Nancy Abudu. Nancy, can you kick us off, please?
Sure. Thank you, Graham, and thank you all for joining us. We welcome you to our commemoration of the 31st anniversary of the Americans with Disabilities Act and discussion of how to meet the Act's promise of full equality for people with disabilities in our country. On this day in 1991, with bipartisan support from both houses of Congress, the ADA was signed into law to ban discrimination against people with disabilities. The purpose of the ADA is to make sure that people with disabilities have the same rights and opportunities as others without disabilities. The ADA gives civil rights protections to individuals similar to those provided to individuals on the basis of race, color, sex, national origin, age, and religion. It guarantees this equal opportunity for individuals with disabilities in public accommodations, employment, transportation, state and local government services, and telecommunications. For centuries, people with disabilities were often misunderstood, ignored, victimized with frequent abuse and violence, including the practice of warehousing. That was the practice of removing people from their communities to institutions that subjected them to abuse and neglect without adequate accommodation or the proper legal protections. So disability advocates in the past century have vastly changed society's paradigm for the better. Veterans returning in the early and mid 20th century made great strides to emphasize rehabilitation, and the modern disability rights movement, led by the prominence of individuals with disabilities and influenced by the civil rights movement, which have all moved us forward still. The modern disability rights movement has helped society understand the commonality of disability as well. According to the CDC, Centers for Disease Control, 1/4 of adults have a disability. Everyone watching today without a present disability could have conditions that could become disabilities at certain times, or may develop a disability in the future from an accident, illness, or age. So let's be clear that disabilities stem from the barriers that society creates that prevent people from living their chosen life. We must continue removing these barriers. One small way is to begin using preferred language to speak about these issues. So during this briefing, we will primarily use people first language. This emphasizes the person, not the disability. By placing the person first, the disability is no longer the primary defining characteristic of an individual, but just an aspect of their identity. Some people in advocacy groups within the larger disability community prefer identity first language. You should always show respect for how a person or organization wants to refer to themselves if they communicate such a preference. The ADA marked a great accomplishment, but we must face, or we currently face, a plethora of challenges to disability rights. And people with disabilities are forced to work in what are known as sheltered workshops that pay far below the minimum wage due to insufficient Social Security and discriminatory wage laws. So the government does not adequately incentivize buildings to comply with the ADA, and we have private healthcare plans that make insurance and treatment too expensive. We also know that COVID-19 intensified already existing difficulties for many with disabilities to be able to vote and get an education. Having certain disabilities increase people's level of risk of long-term health problems or even death from contracting COVID-19. So the SPLC currently has active cases addressing how the prison system abuses and denies treatment for individuals with disabilities, and how new voter suppression laws attempt to diminish the right to vote for Americans with disabilities. People who are incarcerated are 3 times more likely to have a disability, but frequently cannot access treatment and are forced into conditions that exacerbate their disability. And we're very excited to have one of our panelists who's going to address that issue. We also know that several states, including our target states in Alabama, Florida, and Georgia, for example, have created significant barriers to people with disabilities when it comes to making it more difficult, if not impossible, for them to exercise their fundamental right to vote. And so we are asking for Congress to address these issues, especially with respect to voting rights, through passage without any further delay of the For the People Act, which includes the Disability Voting Rights Act. So to that vein, I'm so happy to welcome our first panelist, Dr. Eric Peebles. Dr. Peebles co-founded Accessible Alabama in 2013, using his first-person viewpoint on the needs of persons with disabilities as inspiration for his work. Since then, Eric has served several roles advocating for the rights of persons with disabilities. And in December 2019, Eric was appointed by Governor Kay Ivey to the state of Alabama's Independent Living Council. Without any further ado, I turn it over to you, Eric. Thanks so much. I think you're on mute, Eric. Eric, we just need you to unmute. Eric, can you hear me? I think maybe we're having some technical difficulties. We just need you to unmute if you can, Eric.
Okay.
Thank you.
Yeah. Oh, thank you. I just want to say thank you for inviting Accessible Alabama to be part of this remarkable event. Nancy and Graham have asked me to give some thoughts on the impact of the ADA, and specifically in regards to the education of people with disabilities. As time has progressed. As Nancy mentioned in her intro, the initial focus of education and rehabilitation for people with disabilities in our country focused around veterans returning from World War I, excuse me, as and being skilled as laborers in being trained to reintegrate into the industrial workforce, beginning in the and then beginning in the 20s or so, was the first federal recognition of the need for rehabilitation. So with that, we saw federal programs such as the blind person vendors program, and the federal state PR partnership through the Smith-Fest Act of 1920. But I'm really not going to spend a lot of time on the 100-year-old legislation, because that's just to give you some historical background. That's not really a precursor to where we are today. I'd like to start out with what the recognition of the need for education of all children with disabilities, regardless of the level of severity. This notion was first addressed, I would say, probably in the early 1950s with the foundation of the Association of Retarded Citizens, as it was called then. Now it's just referred to as its acronym ARC. And this was a group of parent advocates who felt a strong need to advocate for their children and with intellectual disabilities. And I believe we have a representative from the Georgia ARC in the call with us today, which we'll be hearing from later. So in the 1950s and 60s, there was a tendency toward exclusive, segregated, sometimes even state-run educational institutions. So, such as the Institutes for the Deaf and Blind, as well as the state developmental centers, such as Partlow in our state and the famous Willowbrook in the New York system on Staten Island, which many of you may know was exposed by a local news reporter out of ABC7 New York by the name of Geraldo Rivera. So looks where that's gotten him. And also coming along in the 70s was the Education of All Handicapped Children Act, which mandated a free and appropriate public education. The principles of free and appropriate public education include zero reject, which means, as I said, every child between the age of 3 and 21 is entitled to a free and appropriate public education, which means, and I have to still look at these just to get them right, but which means, all right, there we go. Free and appropriate public education, which means zero reject, a least restrictive environment, which means that the individual is in a academic environment that is most inclusive with respect to their individual learning needs. And every student is there's not a broad curriculum. There's not a broad generic curriculum for individuals with disabilities. Instead, each student is placed on what we call an individualized education program, which a team of individuals, including parents, teachers, other school professionals, get together at least on an annual basis and define goals and how those goals are going to be met through the particular school district's program. And then there are, of course, due process procedures and non-discriminatory evaluation processes. And then as a follow-up to that, when the act was reauthorized in 1990, the title of the legislation was changed to the Individualized Education of Individuals with Disabilities Education Act of 1990. In this piece of legislation, the concept of transition services was added, which creates a partnership between the public rehabilitation system codified in the Rehabilitation Act of 1973 and the element in the secondary education system, so that students can engage in proactive planning activities to sort of guide the parents and other support persons and the individual to proper post-school planning, whether that's at 18 or 21, depending on the decisions of the IEP team. So how does that affect the ADA? How does that affect the ADA and the Rehab Act? The thing is that once someone exits the school system, everything as far as disability services in education now moves from an institutional responsibility, i.e. the school district was paying for everything while they were in elementary, secondary programming. Now that is pushed onto the vocational rehabilitation system, and in some cases, unfortunately, onto the backs of the student or the young professional. So what is the role of the ADA there? When we get there, there are three main sections of the ADA. We have the employment section, we have the public accommodation section, and we have the private entity section. Occasionally, in higher education and advanced learning, in most cases, those types of things either are covered in Title II if it's a public entity, or Title III if it's a private institution. So then there we look at the question of is the accommodation that the individual is asking for. Two things, first of all, is the individual otherwise qualified for admission to a post-secondary and/or training program? And number two, is the accommodation that the individual is asking for fundamentally alter the academic program which they are enrolling in. So those are the two big issues as to how the ADA and the Rehab Act of 1973 play into education, as it were.
Thank you, Dr. Peebles. I think for sure we want to hopefully during the Q&A get a little bit deeper into those connections and hopefully talk about also the personal experiences of students who are finding themselves in those environments, and for sure is the ADA today addressing some of those issues. But as you made reference to one of our other panelists, Shira Waxschlag, who is with the ARC, and it was interesting to hear about the history, especially in terms of language of the ARC, but I'd like to go ahead and introduce Shira right now. She is the Senior Director of Legal Advocacy and General Counsel for the ARC of the United States, and her work involves directing the ARC's participation in disability rights litigation to advance the rights of people with intellectual and developmental disabilities nationwide. Shira is also on the board of the Disability Rights Bar Association and also a legal counsel team member in the case that I believe she's going to talk about a little bit in Georgia, challenging parts of Georgia's law under the ADA. So Shira.
Thank you, Nancy. Protecting the right of people with disabilities to vote and participate in civic engagement has been a priority of the ARC since it was founded in 1950. The ARC is the largest national community organization advocating for and with people with intellectual and developmental disabilities. In the recent election season, the ARC Georgia engaged in significant voter outreach, helped voters get to the polls, and assisted voters with procuring and delivering absentee ballots. Congress enacted the Americans with Disabilities Act in 1990 to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities and to integrate people with disabilities into the economic and social mainstream of society. This extends to all aspects of public life, including voting. Title II of the ADA prohibits state and local governments from imposing requirements that deny people with disabilities equal access to their programs and activities, including voting, and requires these entities to modify their policies and practices to avoid disability discrimination. People with disabilities already experience barriers in accessing the voting process, and the Georgia law SB 202 has made the process even more inaccessible. SB 202 violates the ADA by denying Georgia voters with disabilities a full and equal opportunity to participate in the state's voting programs. The law imposes restrictions that harm all voters, but disproportionately harm voters of color and voters with disabilities in a number of ways. Voters with disabilities, including those in nursing homes or other congregate settings, are more likely to require assistance when voting, but SB 202 restricts opportunities to provide and receive that assistance. Voters with disabilities are more likely to encounter inaccessible polling places and have trouble getting to the polls due to lack of access to transportation. But SB 202 restricts the use of drop boxes, early voting, and absentee voting, which provide more accessible opportunities for people with disabilities to exercise their right to vote. Voters with disabilities are less likely to be able to withstand long lines at polling places, but SB 202 criminalizes providing them with food and water to help them endure the often hours-long wait. Voters with disabilities encounter more barriers in every step of the voting process, from registering to vote to accessing polling places, and SB 202 makes the process more inaccessible at every stage. The ARC joined the litigation challenging SB 202 in federal court because the law denies voters of color and voters with disabilities equal access to the polls. Nearly 90% of voters with disabilities chose to vote early or absentee in the general and runoff elections. Rather than embracing this unprecedented level of civic participation, the state of Georgia has made the voting process inaccessible and unequal. Diverse stakeholders who sit at the intersection of historically disenfranchised communities have come together in this lawsuit to take a stand against these discriminatory voting restrictions. The partnerships between disability and racial justice groups are critical both to this litigation and to the broader efforts to challenge voter suppression laws and realize the full promise of the ADA. For democracy to work for all of us, it must include equal access for all of our communities, particularly those that have been historically disenfranchised. At the federal level, the ARC is advocating for restoration of the Voting Rights Act and to ensure that any voting legislation provides full and equal access for voters with disabilities. 31 years since the ADA was passed, society has made great strides towards improved access and opportunities for people with disabilities, but so much remains to be done to achieve full equality. Ensuring that people with disabilities have equal access to the fundamental right to vote is critical to realizing the full promise of the ADA. And we'll go back to Nancy, and happy to answer any questions later.
Thank you, Shira. And now I'm very happy to introduce Nancy Anderson. And in addition to serving as the Alabama Disabilities Advocacy Program Associate Director, Nancy also chairs the agency's Children's Advocacy Team, coordinating its individual case and systems change work, conducting outreach on disability rights issues, and representing young clients on a variety of matters, including mental health access, special education, juvenile justice, and Medicaid. Nancy?
Hey, good morning, everyone. I'm very happy to be here. So 31 years old, the ADA is today, and it has dramatically changed the ways in which individuals with disabilities live in the United States. Equal access to community, to employment, to schooling, public accommodations continues to grow. But there's more work to be done nationwide and here in Alabama. And we at ADAP, working alongside partners like those on this call today and others in the community, are here to do that work. ADAP is the federally funded protection and advocacy system for the state of Alabama. We are Alabama's statewide cross-disability legal organization dedicated 100% of the time to protecting and advancing the rights of people with disabilities in the state. We're part of a nationwide system of such protection and advocacy, or P&A agencies, one for each state and territory. For more than 40 years, the P&A system, including ADAP, has worked to advance the rights of individuals with disabilities related to community integration, education, employment, self-determination, access to healthcare, and safety. Our legal work can take many forms. We provide legal representation one-on-one to clients. So at ADAP, we represent hundreds of clients each year across a variety of different disability rights issues. We engage in systemic litigation. We conduct investigations into the abuse and neglect of people with disabilities. And we help individuals with disabilities and their families understand their rights and work to help them enhance their own self-advocacy abilities. What do our clients look like? Well, it could be a person with a mental illness committed to an institution who's being abused or neglected by staff. It could be an individual whose guardian is misappropriating his funds. The child who has been summarily kicked out of school for conduct related to her disability, conduct and behavior which was going unaddressed by the school in the first place. It could be a child with mental illness who's been segregated away in a facility by the state instead of being supported to live in the community. It could be an individual with an intellectual disability who wants to work, wants to contribute to society and pay his or her own way, but who can't get the accommodations to which that person is entitled to support that work effort. It could be the voter. We've heard a lot about voting so far today. It could be the voter whose group home wouldn't help him go and vote on election day. Now, a key impetus for the creation of the P&A system 40 some odd years ago was abuse and neglect happening in facilities serving persons with disabilities. Eric mentioned in his remarks about Willowbrook and the gross abuse and neglect that was happening there. And while our work across the P&A system and at ADAP has diversified a lot over the years, a lot of ADAP's work continues to focus on persons living in or committed to facilities of one sort or another in our state, including, and now I'm going to reference what Nancy spoke about a few minutes ago, including prisons and jails, to ensure that the rights of persons who are incarcerated or who are jailed under the ADA are provided for and that they're free from abuse and neglect. So let me just briefly talk about one of the key pieces of litigation that we are partnering with Splc on, and that involves the prison case against the Alabama Department of Corrections, referred to as Braggs. Almost a decade ago, ADAP exercised our access authority and began an investigation along with Splc into conditions in Alabama prisons and their effects on the lives of people with disabilities who are incarcerated there. ADAP and Splc filed a federal lawsuit in summer of 2014, challenging the unconstitutional conditions in Alabama's prison system and ADA violations. The parties resolved the ADA claim in May of 2016, and the court approved the settlement in the fall of 2016. Then, by agreement of all the parties and the approval of the court, ADAP is monitoring the Department of Corrections compliance with the court-ordered ADA remedies regarding accessibility and accommodations for people with disabilities incarcerated in Alabama's prisons. I'll just conclude my remarks by commenting on where I think our work is going and needs to go at ADAP. Leading into this 31st birthday or anniversary, I've been reading a lot online about the impact of the ADA over the last 31 some odd years. And one comment that I read, and I'm afraid I don't know the woman who made the comment, but it was a person with an intellectual disability. You might know that there are only right now, I think, 17 states that don't have any institution at all for persons with intellectual disabilities. Alabama, happily, is one of those states. We no longer have any institution, no state facility that warehouses people with intellectual disabilities. But we certainly did, and Nancy referenced that earlier when she made her remarks. So this woman that whose remarks I was reading commented, talking about institutions, like the physical place, an institution. But then she went on to say, an institution is any place you do not have control over your life or make your own decisions. So just thinking about that, an institution doesn't necessarily have to be a physical building. An institution can be societal practices. It can be discriminatory acts. It can be misconceptions about people with disabilities. It can be state and local policies. It can be federal policies. It can be stigma. Anything that creates an environment where you don't have control over your life or where you're not able to make your own decisions, a virtual institutionalization. That's what I think we at ADAP are moving or have moved into working on. Of course, we still have our institutional work by way of the comment I made earlier about Braggs, but we're also looking at how state policies create, in essence, a virtual institution or the institutionalization of community, as I've heard it referred to in the past. We want people with disabilities to have control over their own lives, to be able to make their own decisions, to live the lives that they choose, whether it's through employment or whether it's through where they're housed, how they spend their day. That's where I see ADAP's work going in the coming years. So I'll finish there.
Thank you, Nancy. Thank you, everyone, Shira and Eric as well. And we want to encourage those who are participating to send their questions. We've got a team of folks at the SPLC who are gathering questions, and we encourage you to ask. But I really want to start and go back to Eric, because I know you were going down the train in terms of the education and its intersection with the ADA. But I want to ask particularly about the human experience of this, because we have what the law requires, but then we have what students are experiencing. Can you talk to us about what students are experiencing and whether or not the ADA and other related laws are really sufficient, or do we need to petition Congress for more? Just want to make sure you're not on mute, Eric. I think you're still on mute.
Are we? Yeah. Can you hear me now?
Yes.
All right, good. This is actually one portion of the. This is actually one portion of the what. This is the one portion of the area is higher education and post-school options that is very near and dear to that is very near and dear to my heart, with almost between my own education and then working in higher education after that. I've spent almost 18 years working in with public institutions, and the problem becomes really, and I've heard this from my own experience and then from the students that I worked with in an academic advisory role, is the problem becomes there's two. First of all, there's realistic expectations as far as what is this person going to be able to, is this person going to be able to choose a career field? That is this person going to be able to operate in a career field that is with a sufficient income to cover their cost of care? So basically, what I like to put this as is it worth, first of all, for someone with the dyscalculia, diagnosis of dyscalculia, which is a learning disability that has to do with the individual's ability to do complex math, it wouldn't be appropriate for a guidance counselor, vocational rehabilitation, counselor or university disability services professional to encourage a career in one of the STEM fields like engineering, because we know that mathematical calculations are an essential function of most any job that you'd find in the engineering or STEM fields. So that's what, first of all, right, we have to stop with disingenuous recommendations from those, and the real transition process occurs when there is a collaboration between universities that have gone beyond what the minimum federal law requires under the ADA and the Rehabilitation Act to really take a proactive approach to disability management, which there are, just not very many of them around here. But in those types of institutions, like the University of Illinois, or where I went, the Wright State University, or Cal Berkeley, those places need to really be focusing on, pairing students and their families with career fields that align with their strengths and abilities, and will cover their cost of care, either with or without support. That's what I refer to as, that's what I refer to as a livable wage. The ability to cover your cost of care as a person with a disability, either with or without support. So that's part one. Part two.
Well, I will just, and I apologize to interrupt. We only have about 7 minutes left. I wanted to make sure that Nancy and Shira also get to weigh in, if that's okay. And we did get a question from a reporter that wants to know how the ADA has been implemented specifically in the South. And I'm going to pose this question to Nancy. And even though it's a broad question, I'm going to ask if you could insert a little bit about the prison conditions, because I was alarmed by the statistic that about a third of those who are incarcerated are also facing some kind of disability, which means you have a concentration and a special perhaps need for the ADA to be strongly enforced, perhaps.
Yes, the rate of disability among, broadly speaking, in the criminal justice system is high. And certainly in the work that ADAP and SPLC did in investigating the conditions in, for instance, the Alabama prisons, we identified many ways in which people with disabilities were not provided the accommodations, whether it be physical access or programming access to which they were entitled, thereby hampering their health, their programming in the facilities, et cetera.
And then I guess in the broader question of how the ADA has been implemented in the South, not to pick on the South, but it seems like there historically has been some resistance to federal legislation in general. So what would you say on that front?
Well, I can speak for Alabama. I don't want to speak broadly across the South. I know, you know, as I referenced a few minutes ago, one of the things that we are really focusing on right now at ADAP is making sure that state policies support people with disabilities having opportunities in the community. That was the promise of the ADA. It was what undergirded the Supreme Court's decision in Olmstead, that the recognizing the rights of individuals with disabilities to live the lives they choose in the community, to be served by the state in ways that are in the least restrictive environment. So where our work now tends to be looking, or we look a lot at, is in terms of access to education. Eric talked a lot about that. Improving access to employment, competitive integrated employment, meaning a person with disability is paid a competitive wage, works in the community, just like any of us on this call are working in the community. The rate of employment among people with disabilities is very low. I think most recently I saw, or some of the most recent data I saw was that back in 2017, I think 12% of persons with intellectual or developmental disabilities are employed in competitive integrated employment in Alabama. That needs to change.
Yeah, Nancy, that's right. That's right. That's what we were looking at for the employment report. That's correct.
Yeah. And employment is something that brings meaning to a person's life. It's something that puts them into the community. If you have people with disabilities where they're in a job that pays less than minimum wage, or where their lives, their activities are chosen for them by others, or where they're doing something because everyone else in some kind of state-supported group is doing that activity, or they're going places that they have no choice over. They're doing things that they have no choice over. That suggests a construct of state supports for people with disabilities that inhibit them from being fully part of their community. And those are some of the challenges that we're working on right now at ADAP.
That's great. And I think we can round it out with only 2 minutes to go. Shira, at the end of the day, some would say this is all about political participation and making sure that those voices that are most impacted by these policies are really heard. So tell us a little bit about what you are advocating and recommending to the audience in terms of making sure that we're pushing forward on that front.
Sure. So everything that Nancy and Eric have said about the values that are underlying our advocacy is similar to the ARC's principles here, which is that people with disabilities are entitled to self-determination and to have their voices heard and respected and their rights enforced and protected. And voting is a totally fundamental piece of that. If you're gonna be able to live in the community in the way that you choose and ensure that civil rights laws are enforced and protected and expanded upon, being able to vote in order to make that happen is a totally fundamental part of civic participation, of self-determination, and ensuring that all of the principles that we're talking about today, including community integration, are actually realized 31 years after the ADA was passed. So I think you know, with all of the different laws and restrictions that are both being passed and debated and considered in different states around the country, and of course in Georgia and other states, some of these have already passed, the ARC and I think a number of members of the disability community are just going to keep fighting that to make sure that people with disabilities can exercise their self-determination, can exercise their fundamental right to vote, and make sure that we actually can see the full promise of the ADA 31 years later, because without that, we can't realize those civil rights.
Thank you. I think that's a perfect way to wrap up, that we have to keep fighting, pushing for the full protection, the full realizations of the ADA. So I just want to sincerely thank Eric and Nancy and Shira for joining us this morning, for all of you who have also joined to learn more about this information. And at this point, I'm going to turn it over to my colleague, Graham, to close us out.
Thanks, everyone. I'm putting in the chat some email addresses, but we're almost out of time. So I'll be sure within a follow-up email to be sent out to everyone who RSVP'd. That'll include the link to this briefing, both audio and video, transcript when we get it as well later in the day, as well as these email addresses on the last slide, Courtney, if you want to pull it up. Thanks, everyone, for joining us. Thanks, Shira, Dr. Peebles, Nancy, and Nancy as well. Appreciate all your support.
Thank you.
Thank you.
Take care, everyone.
Thank you.